Okay, some of the statutes that affect information security have their own history, their own logic to them, that I'm not going to be able to cover in enough detail for you to actually understand all of the nuanced issues that go into them. And my goal in going through any of them at all is to simply give you a flavor for the kinds of issues that we do see in information security related regulations and the sorts of problems that you can expect to deal with as an information security professional. And I'm only going to be able to highlight some of the stuff that's covered in the textbook. I feel like this is the sort of thing that if you're really interested in it, you're just really interested in it. And for those of you who are kind of only partially interested in information technology law, it's a little bit difficult to get into. And I want to get to the point where, at least for that second group, the people who are not as interested, you can see why it might be so relevant to the actual day-to-day life of an information security professional that you need to know a little bit about it. And I'm going to start with the Computer Fraud and Abuse Act. This was passed in 1986, so think back to 1986. I know most of you probably were not even born by 1986. And it was a long, long time ago from a technology standpoint. It has been amended, but the basic underlying premise behind the Computer Fraud and Abuse Act really has not changed since 1986. The idea is it's preventing people from using computers without authorization or from using computers in excess of the granted authorization that they had. This is replacing essentially mail fraud and wire fraud, which was the prior statute people used to compute to enforce problems, enforce lawsuits, and enforce the law against computer violations. Essentially using an analogy to say, well, a transmission over a computer is very similar to wire fraud. Or if you're sending an email fraudulently, it's sort of like sending fraudulent mail, right? Not a great analogy, and so they had to create something, and this is what they created way back in 1986. During the Reagan administration. Now, the main criticism for this is its vague, overly broad definition of authorization. Right? You could interpret it to include many, many normal uses of internet services, and a lot of internet technology scholars have viewed this law negatively as a result of that. Tim Wu, who coined the term network neutrality, refers to the CFAA as the worst law in technology. And I'll go through one example case here so you kind of get a sense of what this law could do and why it works. Aaron Swartz was prosecuted under a violation of the CFAA. A little bit of background, he was an internet pioneer, co-founded Reddit, helped create the RSS protocol, and did some revisions to markdown formats. He was also very active in legal and policy development for intellectual property law, very active in the Creative Commons organization, and an advocate for making academic articles more widely available. And in 2011, he was caught using a hidden computer on MIT's campus to download articles from JSTOR, which is a repository that has a lot of these copyrighted articles that are made available by the MIT library on their network, but not intended to be available just to anyone, right? And you shouldn't be able to download literally millions of them in the way that he was trying to do using this hidden computer. After he was caught, he was charged under the CFAA and had, at the time he committed suicide, $1 million in fines and up to 35 years in prison on the slate. And he wanted to fight this simply because he felt there was a policy point to be made. So he had turned down a plea bargain that would have, I think, given him like 6 or 8 months in federal prison because he wanted to actually have the legal case. But the stress of going through this is what many people believe led to his suicide. And when you look at the penalties associated with the CFAA for downloading an academic article, downloading a series of academic articles, it seems a little extreme, right? Like 35 years in prison for going to the library and downloading a whole bunch of stuff just feels a little bit, especially compared to some of the other white-collar type crimes that we've seen and the very slap-on-the-wrist kind of penalties that have come from those. So this is a famous CFAA application, a famous case, and certainly a problematic one. A lot of people would look at prosecutorial discretion as a reasonable thing that could have happened here but did not happen here. And that's not something you want to hold against the CFAA, but it is worth pointing out that these are the kinds of things that people have been complaining about with the CFAA. Now, if you're JSTOR, this is actually kind of good for you, right? You'd rather have somebody protecting your intellectual properties, especially because that's essentially all JSTOR has. That's the whole product they produce. They manage manage access to academic articles. So it is, at least from a business standpoint, theoretically valuable in that sort of a context. The question is, should it be enforced with this kind of enforcement mechanism? Another law that I wanted to talk about is the Electronic Communications Privacy Act. This is similarly old. It was passed in 1986. It's been amended many times since, once for the Communications Assistance for Law Enforcement Act, once for the Patriot Act, and once for the FISA Amendments Act. And you'll see a lot of the older technology laws or older laws related to technology have that same pattern. They've amended either by CALEA in response to police concerns about going dark, or to national security related incidents like the Patriot Act after 9/11, the FISA Amendments Act after some of those provisions would have sunset. Now, the whole idea behind the ECPA is that it extends protections for telecommunications, basically the protections that currently existed for phones, to transmissions of electronic data. And that is certainly a laudable goal, but transmission is much less important now than access, use, and storage with cloud services. So this law may have made sense in 1986, but has not aged well. And since the whole law is premised on transmission, it's very difficult to use appropriately in modern contexts. Another criticism of the ECPA is that it does not protect metadata. So you might be able to get access to somebody's records in terms of like who they're communicating with and how often they're communicating with much more easily as a law enforcement agency than you would the actual communications data itself. So essentially, what was the message that was being transmitted from one place to another? And there's an article here that I've linked to on Yahoo Finance with this very good introduction to the history of the ECPA and some of the problems that are associated with the ECPA. They're essentially saying like, one of all the good tech policy ideas dying a slow death, none has sunk to a deeper level of Groundhog Day futility than an effort to reform the ECPA, right? We do need to protect this data. It's obviously something that's valuable and should be protected legally, if not practically from an information security standpoint. The problem is we cannot seem to agree on how to make this more focused on storage and access than it is right now, because right now it seems like it's basically just affecting transmission of data. A good example of this would be something like email, which for many, many decades was essentially protected only for the first 6 months. And after that, stored email was assumed to be abandoned, and that there was no ECPA protection for it. Of course, now everyone stores all of their email forever, indefinitely, in something like Gmail or Yahoo or AOL or whatever, some online service. And the idea of downloading it after just a week or two, or even 6-7 months, is kind of ridiculous. Of course, there are many other statutes that affect computers and computing. I'm going to very quickly go through some that are mentioned in the textbook, some in some detail in the textbook. The Espionage Act outlaws computer use for foreign espionage, and it is a very powerful piece of legislation. This is actually what people want to charge Edward Snowden under if we are able to get him back to the United States jurisdiction. The Freedom of Information Act provides public access to government information. Essentially, the process is used by executive agency branches of the U.S. government. And it's very valuable from an information security standpoint, because then you will know how something like the Census Bureau is protecting census data, right? You can use the FOIA Act to get access to that sort of the internal documents of how they're doing that sort of protection, or voter registration lists or any number of other things. The Privacy Act of 1974 protects personal data collected by the government, and this is mostly a regulation telling federal government information systems what they can and cannot do with personal data of employees, but also affecting some citizen data. So if you're an employee of the federal government, this is a very important piece of legislation for you. Gramm-Leach-Bliley Act is a law regulating financial institutions to make sure that there are basic security risk assessments in place, and that there's an auditing process and so on and so forth. I think there are a lot of other regulations in finance that are pretty important, but they're regional or state-based. Like New York has a number of financial regulations that are really critical and not federal. And because most organizations do business in New York, they are compliant with those regulations everywhere. Same sort of thing happens with HIPAA and healthcare. HIPAA protects healthcare information, and because of the way that electronic health records are made, and it's a federal law, it ends up affecting a lot more than just the United States. A lot of organizations will also deploy these medical systems in other jurisdictions that have similar regulations. Like Canada has PIPETA. I can't pronounce the acronyms. I just see it on the screen, I suppose. And then the USA Patriot Act, another very important statute that affects computing. Essentially, this is giving law enforcement a much easier path to obtaining wiretaps on potential foreign agents. And this is critical. It has to be a potential foreign agent in order to make a case for some kind of a computer systems felony, like a violation of the CFAA or the ECPA. And then finally, another list of statutes that are really critical and affect computing. The CAN-SPAM Act, which a lot of people would like to see updated more regularly to address text message-based advertising and similar advertising. Essentially, this is banning deceptive email advertising and requiring opt-outs to be published in any email that you're sent. So imagine all of those emails you get from mailing lists that you may or may not have signed up for not having an opt-out option. That's kind of what the situation was prior to the CAN-SPAM Act. Not a great deal. And then the California data breach notification requirements. Essentially, if you're doing business in California, you're required to notify individuals of data breaches. I think I have previously mentioned in this class the conflict that we had with Massachusetts data breach notification requirements, which essentially said you can't give very much information to the citizens who have been affected by this other than the fact that there has been a data breach. And California had the opposite. You're sort of required to tell them more specifics about what happened. The Council of Europe Agreement on Cybercrime, this is an EU regulation, essentially requiring countries that are part of the EU at this level to define cybercrime activities and support investigations across national boundaries. These kinds of agreements are very, very important. If you're talking outside of the EU, nation-state agreements are mutual legal assistance treaties. And reforming the MLAT process is a very important piece of being able to investigate large-scale criminal organizations who have used computers as a part of that process. Very important piece of legislation to keep your eye on if you're interested in doing business in foreign countries, or if you work in an industry where there's lots of foreign data transfer. Then the GDPR, this is the Privacy Rights and Protection Act that is available for citizens of the EU member countries. The California Consumer Privacy Act is sort of the American version of this, but it's a lot more vague and doesn't include all of the same specifics that the GDPR does. It's also the sort of thing that is a little bit newer than GDPR, and I mean that mostly in the sense that we don't have good case law showing that this is how it will be enforced. So there's lots of uncertainty in exactly how this sort of stuff will be enforced down the road. But it's something you should keep an eye on if you're an information security professional, because all of these laws and regulations can have a material impact on the sorts of things that you should be doing as a part of your job and how you should be documenting them, so that if there is a legal action or if you need to take legal action yourself, you're very well positioned to do so.